parking space will still be empty, and you can park in it. And why do people respect this claim of property, which has absolutely no basis in law? You have no legal claim to the parking place at all. Well, people in that area know perfectly well that if they remove your chair and park in your parking place, which is how you see it and they see it, and then go off, when they come back, their mirror might be broken. Or maybe the car won't have an antenna anymore. Or maybe there'll be a deep scratch on it somewhere. And that, I would claim, is, in a milder level, the same pattern of behavior, of commitment to take action that defends your property that we observe in non-human species. So the starting claim is a fairly simple claim, which is that the idea of the institution of private property does not originate with government, does not depend for its enforcement on government, and could not depend in enforcement on government, because then what would the institution of government depend on? That is, something has got to be maintaining the various claims of the people who are purportedly enforcing the law beyond themselves. You can't pull yourself up by your own bootstraps. And what that something is an elaborate network of mutually consistent commitment strategies where everybody has some idea of what he's entitled to, will fight in, sometimes they do their fighting in courtrooms instead of in arenas, but fight in some form, will bear costs to impose costs on other people if those people violate what they see as their rights. Let me go on to a rather different issue, which is how you enforce contracts without law, without government. And I initially got into thinking about this question, well, part of what got me into thinking about this question were two very different real-world examples. One of them was Imperial China, and one of them was cyberspace. And in fact, I've got an article up on my website, a published article, called From Imperial China to Cyberspace. Imperial China, because I teach a seminar every other year, have been, on legal systems very different from ours. The standard comparative law class, from my standpoint, is teaching you about mildly different variants of the same legal system, modern American law, modern European law, and so forth. We start with modern gypsies, go on to Imperial China, classical Athens, Cheyenne Indians, Saga period Iceland, try to look at a whole lot of different societies, all of which face about the same problems as our society in different forms, but have solved them in an interestingly variety of ways. And where Imperial China comes into this is not that it didn't have a state, of course, it had a very formidable state, but it didn't, as far as I can tell, have any civil law. And such fragments of contract law as it had weren't enforced. So that if you lent somebody money and he didn't pay you back, there was no way to sue him. Your only legal recourse was to go to the district magistrate and accuse him of being a swindler, at which point the district magistrate could ignore your accusation. He could say to the guy, give him half the money and we'll forget about it. He could say to the guy, I don't care what you do, I'm going to have you punished for being a swindler. It was entirely out of your hands. It wasn't anything equivalent to suing for breach of contract in our society. About 1900, China ceded Taiwan to Japan. And the Japanese decided that instead of trying to enforce Japanese law in Taiwan, they would simply enforce the existing Chinese law. And of course, the first thing they had to do in order to enforce existing Chinese law was to find out what it was. And so there was a large-scale scholarly project producing, I gather, many volumes in Japanese, investigating the current state of law and legal practice in Taiwan. And a modern scholar mined that source, among other things, to write a chapter on contract. And it turns out that in Taiwan in 1900, there was essentially no contract law and very elaborate contractual practice. So that a modern lawyer would be perfectly at home, aside from not knowing the language, in terms of the range of different sorts of contracts that were available in that society. And so the question is, how do they pull it off? And the answer is largely by writing contracts in ways so that you never need to go to court to enforce them. And this also interested me because I'm interested in the future of a world where more and more of our activities happen online, increasingly through virtual reality, which is developing pretty rapidly. And in that world, it's very hard to use the mechanism of government courts to enforce things, because the internet has transparent national boundaries. You don't know what country somebody's in who you deal with. You may not even know who he is. You can function anonymously online if you like. And the result is that you need other mechanisms to enforce agreements online. And so it struck me as an interesting parallel between these two very different societies. And so I tried to think about and look at how they did it. And it eventually occurred to me that what I was looking at ought to be of interest to people like you as well. Because, of course, the real job of a lawyer isn't to go into court, but to stay out of court. That is, the real job of a lawyer, if you imagine you're drafting a contract, is you would like to draft the contract in such a way that no one will ever have to sue anybody else. Well, if you look at societies where you couldn't sue someone, that's going to give you some useful lessons on how to do it. So let me discuss a little bit the general topic of self-enforcing contracts, contracts which don't require a court to enforce them. The simplest one is what's sometimes referred to as the discipline of constant dealing. If two people or two firms are engaged in commercial transactions over a long period of time, each of them knows that it will be much worse off if the other refuses to deal with it. Each of them has an incentive to keep its agreements in order not to lose the opportunity to make future agreements. That's sort of the simplest case, which I would guess is responsible for probably more contract enforcement in a modern society like ours than is the formal legal system. The second version, which is sort of a more indirect version of that, is what I like to refer to as reputational enforcement. So if you imagine that you buy a jacket at a store which tells you money back, no questions if you don't like it, and you get it home and your wife explains to you that purple is really not your color and decides the sleeves are too long and you take it back, the reason they take it back is probably not that they think that you'll sue them if they don't. The reason they keep their agreement, the reason they don't make some excuse for refusing to take it back, is that not only will you stop buying at that store if they don't, that's the discipline of constant dealings, but lots of other people will too after you tell them about your experience. So they are concerned with their reputation. And again, I suspect that the main reason why most businesses most of the time don't cheat their customers in that sort of way, do keep their contracts, is reputational and not legal enforcement. You know, you're spending your time at law school, but I think lawyers overestimate how important they are, and that large parts of what happens in the world don't depend on it. But then that gets me thinking about how reputational enforcement works. Because most activities in sort of a market society, the function of the activity and the incentive for the activity are closely linked. All right? The function of growing food is that people can eat it. And the reward for growing food is that people who want to eat it pay you for it. Reputational enforcement isn't like that. Because when the department store refuses to take back the jacket and I tell everybody I know about it, the reason they stop shopping at the department store is not that they want to avenge me. Some of the people I tell about it may not even like me. It's that they don't want to get cheated themselves. So the effect is to enforce the department store's contract with me, but the motive is to protect themselves. And this raises a fairly serious problem. Suppose that you and I have a contractual disagreement and I claim you violated the contract. You naturally will claim that you didn't. Indeed, you'll claim that I violated the contract. And now suppose a third party has no easy way of figuring out which of us is at fault. How will the third party rationally behave? Yep?
I guess not deal with either one.
Very good. The third party will say, one of them is an unreliable trading partner. I don't know which one. There are other people in the world. But if I know that that's how the third party will behave, then I'm never going to accuse you in the first place, because it'll hurt me as well as you. So what that tells you is that in order for reputational enforcement to work, the costs to interested third parties of finding out who is at fault have to be low. And if the cost to interested third parties of finding out who is at fault are high, then they won't bother, they will simply trade with other people. And that then raises the interesting point that one function of arbitration mechanisms, even when they have no enforcement, is generating information. So that imagine that before you and I sign the contract,